James Allsop AC is a giant of the Australian legal fraternity. His reputation precedes him, and in this episode, the Elephants do a deep dive into James's perspectives on everything from the role of the judge, judicial bullying, the Novak Djokovic legal unreasonableness case, and the learnings about right brain thinking he got from reading the book The Master and His Emissary by famed polymath and thinker Dr Iain McGilchrist. And much more. So let's get started.
Welcome to Elephant in the Courtroom. My name's Nick Hogan, and sitting next to me is Awais Ahmad. We are both barristers at the New South Wales Bar in Sydney, and we like to look behind the routine appearance of the law. We want to share a few little hidden gems going on in courtrooms, some first-hand insights from those who play a role in it. And those kinds of things. We'll cover topical things, experiences, stuff we think you might find interesting, and we'll try not to undermine your confidence in the rule of law, won't we, Vassie?
Well, that's always our goal. Yeah. Nick, thanks for having us back here. It's been a few months since our last episode, but I'm glad to be here, and I'm also very grateful to the Wesley Mission Conference Centre to be here in their beautiful studios and all the help that David, our production manager, does. But can't wait to get into what is really a giant episode, I hope.
Well, giant being the operative word, Bussy. I mean, we have today both very excited to have a colossus of the Australian legal scene, if you can call it that, with us today. He is soon to release a book entitled The Humanity of the Law, and there's very much in that title actually that we will get to when we speak to this particular guest. It's a collection of essays and speeches given by none other than the Honorary James Allsop AC. Yes. And among many of the impressive aspects of his curriculum vitae, which we shall deal with shortly, that he was, of course, the Chief Justice of the Federal Court for 10 years, between 2013 and 2023.
And Allsop P in the Supreme Court.
In the Court of Appeal.
Sorry,
yes.
in the Court of Appeal,
yeah,
which is that makes him the President of the New South Wales Court of Appeal.
Indeed, the P, yeah. So
we are lucky to have him, and he is a colossus, and we're even more lucky to have been given an advance copy of this book that hasn't come to even print yet. We couldn't even get a handle of the hard copy. That's being released we're here on the 15th of November. In about 12 days, on the 27th of November, there's a book launch.
Yeah.
It's a collection of papers edited by our wonderful President Ruth Higgins of Senior Counsel of the New South Wales Bar Association, and good friend of the show, Dr Kevin Connor of Senior Counsel.
Yes.
He and Miss Higgins have put together a fascinating collection of papers and speeches that His Honour.
It's great. It's done in these sort of sections, and out of each of these sections, the speeches are ordered and essays are ordered in somewhat thematically. There's some really great and fascinating themes for judging, as in being a judge, and working as a barrister or a solicitor in litigation.
Can I tell you the parts? Well, I think it's incredibly significant that His Honour Justice Stephen Gageler of the High Court AC writes the foreword, but then the book is divided into 6 parts. Part 1 is called The Humanity of the Law.
Yeah, hence the title.
Yeah. Part 2, interestingly, is called Thinking About the Law. Not sure we do enough thinking about the law, but that's probably why there are 4 papers devoted to it. Part 3, Reflections on Public Power, which probably is largely in the context of administrative law decision-making.
Yeah.
Part 5, which I think is a fascinating area, is to do with the profession. I'm sorry, part 4 is the profession, part 5 is commercial law, and part 6 is maritime and insurance, all areas that His Honour was, as you say, a colossus in.
Yeah.
What does the word colossus come from?
I believe it comes from, it emanates from Colosseum, which is obviously something that most people are familiar with. It probably comes from Latin.
Yes.
And possibly even Greek.
Okay.
But why does that interest you?
Oh, just the word. It's just, how do you describe such a giant?
Would you say in some contexts you describe yourself as a colossus?
Well, physically, mentally, probably not.
That'd be inappropriate to say.
But no, I mean, it's just such a. What superlatives do you give His Honour? I mean, given his contribution.
It's a giant, and it's someone who has had an enormous impact, but has had a great presence.
Yes.
And an enormous and I think brave contribution, and that's part of all the things that I take from that word.
Kind of like the brave gladiators in the Colosseum. Perhaps. Just standing up to rudimentary thinking, perhaps even.
I can see where you're going. You're going to bring this back to popular culture, aren't you?
Well, I mean, I'm very excited. I'm very excited about Gladiator too, but that's a very very different issue.
No. Well, a different issue, but a different kind of hero. Now, one of the really interesting things that comes out of the book is this idea about right and left brain thinking.
Yes. I was going to ask you, are you right brain operative or left brain operative? What do you think?
I think I'm more naturally right brain.
Okay.
And I think I've had to probably, and neuroplasticity would suggest that this is actually possible, to develop my left side of the brain thinking, which is obviously more based on an analysis, categorization, rule making, rule forming, defining, all that sort of stuff. It's the brain's want, if you like, to categorize things into recognizable rubrics.
Well,
and then the right brain comes in and steps back and is conceptual, is intuitive, all of the things that sometimes I think lawyers find a little bit uncomfortable and not necessarily driven towards certainty and other things that a lot of people think are important aspects of the law, which are of course important aspects of the law. But
well, I was having this conversation with my wife last night about whether she thinks I am right brain or left brain, and she says in any of our arguments, she says I tend to get to fixate on logic and abstraction and label in the left brain, but otherwise she describes me largely as being right thinking. But it's funny, isn't it? Because the law really requires, well, I think what His Honour's been championing in his papers and using the influences of Dr McGilchrist is to say not to forget and to in fact really imbue the power of the right brain and move away from rigid taxonomy. But I think he's been drawing heavily from Dr Iain McGilchrist, who's a very popular psychiatrist and specialist in neuroscience, and he has the most famous of his publication is the Master and His Emissary. There is a video.
Is that one of those words, emissary?
Emissary, yeah.
Or not emissary. Emissary, is that who you
Well, I've
got a double S, but anyway.
I spent last night awake trying to get that.
Who's the
pronunciation.
master? What's the master and what's the emissary? Is the right or the left brain in that title? I think maybe James might be able to clarify a few of these things.
He
Did
will.
you want to play something?
Yeah,
it looks like you've been around there with your iPad.
Yep, no, it's ready to go. Let me just play what Dr McGilchrist says.
The left hemisphere, this is the first point to make, is not designed to help us understand the world. It's only designed to help us utilize it or manipulate it. And because of this particularistic, very narrow beam, precise attention to detail, what it sees is a world made up of fragments, bits that are decontextualized, abstracted, categorized, inanimate effectively, and fixed so that they can be grabbed easily. By contrast, the right hemisphere sees a world in which nothing is atomistic because everything is ultimately connected to everything else, that it is moving, not fixed, that it is, importantly, what it is in a context. That context is often the body, and that everything is actually unique, not just an exemplar of a category. You've got these two kinds of visions of the world vying. It's very striking.
I like that. Do you know that might be a really good point to actually introduce our illustrious guest?
Wonderful.
It gives me great pleasure to introduce a guest on our show today. This man is to say he is an overachiever and has been for a number of years would be an understatement. An enormous contributor to legal life and the judiciary in Australia and beyond it, and has done so not only for any of his own ends, but also to give to the wider legal community. And he was admitted to the New South Wales Bar in 1981. He was made senior counsel in 1994. So appears to have gone to Western Australia and achieved Queen's Counsel in 1998, and then became a judge of the Federal Court in 2001. Went off to to become the president of the Court of New South Wales Court of Appeal in 2008 until 2013, and then was the Chief Justice, of course, of the Federal Court in 2013 for 10 years. He's also been made Officer of the Order of Australia in 2013, and then Companion of the Order of Australia in 2023 for eminent service to the judiciary and the law. He's none other than the Honorary James Allsop AC. Welcome, James.
Thank you.
So, James, obviously we've had, as we're arranging to have you on today, we've had some email correspondence, and we've noted and marvelled at the incredible brevity of your communications, and we were musing whether it's because as we understand it, you've written in excess or been involved in the writing in excess of 1,000 judgments while you were a judge. There's this book coming out of your essays and speeches. You maybe, is it that you've just done so much writing that you just really don't want to waste any words these days?
Well, I was chipped more than once for writing too much. So.
Well, I mean, I must say, this is...
But it was incredibly succinct and efficient. James, are you free on Friday? Why? Yes. What's your availability during November? We would love to have you. It's a great show. We're so wanted. W/C 7 November, week commencing 7 November.
I love it. It's so effective. I kind of I'd like to adopt it.
Is it the limitations of text, Matt? Maybe.
Yeah. No, there's limits of text. That's another kind of limits of text.
Yeah. Well, we can get to that. This might be a springboard into some of the bigger themes that we wanted to discuss with you today. But just while we're in background mode, so. You look. It appears that we've done a little bit of research that you did your arts and law degrees at Sydney over about 10 years.
Yeah, I started doing arts law.
Right.
And then first year arts law, I hadn't got off the bike and was still pedalling as hard as I possibly could. And sort of after school, and then second year, you hit a kind of reality wall. There's another big wide world out there. And I won't say who it was, but the lecturer in they quite properly called Constitutional Law 1, which was administrative law.
Right.
Drove me from the field. I thought this is just nonsense. This is just kind of learning little things and learning a whole bunch of propositions from cases.
The field of law.
That's fantastic. Yeah. So I announced to my parents that I was going to drop arts law and finish my arts degree and become a school teacher. So, which is what I did, but got the bug to go back and study when I was teaching. After the first year's teaching, and then the second year's teaching, I was teaching at Morris Brothers Cogra, and I enrolled part-time with all the detectives and other people in part-time law Uni New South Wales because you could do it part-time after work. It started at about, you skip, the police could get their shifts and we started at about 4 and had 2 hours of lectures twice a week. So about 4, maybe it was 3 days a week, I can't remember. And I enjoyed it so much, I decided that I'd keep going. It was just to study. It wasn't to, it was to see, because I got the bug to go and study again.
Not to practice necessarily.
No. And then the next year I got allocated year 11, I think, as well as year 2 to year 7 to as well as year 11, and I couldn't do justice to the boys who I was teaching, or do justice to myself to teach the origins of the First World War as well as going and studying common law too. So I decided I'll make up my mind at the end of the year as to whether I'd go on with some more study in arts and history or go into the law. So at the end of the year I went to see my old lecturer in history, rather grim man, nice man but rather grim, and he asked me a simple question. He said, "Did you try in the last year?" And I should have answered it more fully and said, within the limits of going out and playing cricket and playing football and going parties, I tried as best I could. Instead of that, I just said yes. And so he closed the folder and he said, "Well, no, you can't do honours, then go goodbye."
Right.
If that's the best you can do, I'm trying. So I thought, okay, well. So I went back to Sydney full time for 3 years. I'd sort of saved some money up 3 years teaching. And I went back. And I really did it to sort of prove to myself I could get because I'd trashed my arts degree. It was a shocker. And I was enjoying studying. And anyway, that's why I went back to just prove to myself that I could do a worthwhile degree.
You certainly did that though, didn't you? I mean, you got the medal. So.
Well, there's a story to that too. I should have come second.
Well, how does the person who came second feel about that? Or
well, you see, they added your marks up. That's all they did at Sydney. They added your marks up, and they didn't drop didn't give you drop your worst off and take your best off.
Right.
And I had my constitutional law 1 mark, which was about 51%.
I was going to ask you about what you got in admin law.
Yeah, and so I could never catch up. And there was a woman, she's there who I haven't seen for years. She was one of the kind of the mature age student crowd that I was in when I went back. A woman called Sue May, who a very nice woman, and she became pregnant in her last year, and then there were problems, not with the baby, but with the marriage, and so she kind of.
She might have got the medal, but
well, she certainly would have. But she came second, but she had the baby in about a month before them.
So she had some challenges. Perhaps
she had a few challenges that I didn't.
Yeah.
And she didn't do as well that year as she should have.
Well, we'll come back to maybe the real reason you should have come first, which was maybe they marked you incorrectly in admin law in university. We'll come back to the way in which maybe admin law was taught, because I certainly never enjoyed it at university, the way it's taught, and I love the way the jurisprudence developed. That's going a bit further.
Well, they taught it as administrative law instead of, they called it the right thing, but it was, and it's one of the problems with teaching undergraduate law to younger people. It's just a massive. It's a little bit like medicine. You have to learn all this stuff before you can start thinking about it. You can't just think about it kind of conceptually unless you've swallowed and digested enough of it. And in a pure lecture model as Sydney was at that time, it's not as interesting. And that's why I found Uni New South Wales was a more interesting undergraduate, because it was through a textbook method of a Socratic method.
And a whole lot of rigid categories without context.
Yeah, exactly.
So
you wasted no time though, went straight to the bar. You didn't feel like you wanted to go and be a solicitor and get a
Well, there was a story to that, I think. I've never been told the story, but and it's probably simply be in modern day and age be branded as some form of white privilege. Alice Tay, who was this marvellous woman, who was the professor of jurisprudence, I'd done jurisprudence my last year, and she rang me up. She used to procure the associate for the new chief judge of the federal court every year because she knew him quite well, Nigel Bryan. And she was a wonderful actor. She, not without her controversy. At Sydney University, she had a huge fight, I think, with Julius Stone, who then went to the University of New South Wales. And she was married to an academic in Canberra called Eugene Kamenka, really intelligent woman. She,
rings a bell.
You know, I think quite a wealthy middle-class family from China who came to Australia after the revolution. And she rang me up and she said, "You have an interview with Sir Nigel Bowen tomorrow for his job as his associate." I said, "Well, I can't do that, Alice, because I'm working at Freehill." She said, "Don't be silly.
I'm busy."
Who are you working with?" I said, "Kim Santo." She said, "Oh, I'll speak to Kim. You just be Nigel Bowen's office. Be there." Because she used to get Nigel the medalist every year.
Yeah, right. There you go. When that was you, so
Yeah,
things might have been quite different.
Exactly.
Again,
No. Well, that's exactly right. Because Nigel was a wonderful. He was fantastic man. You know, really. He was. I thought he was so old. He was. You know, at least he was. He was 69, 70 when. So he might, you know, a bit younger than me. When I was working with him, and man of very few words, and there was also Sir William Dean was.
I've heard of him.
Court.
Yeah.
So you were,
and and Nigel said, "You know, what are you going to do when you leave?" I said, "Oh, I'll go back to Freehill." But think about going to the bar. I said,
Amazing having interviewed those two people at once as well.
Yeah, and Brennan. You know, the court, that was a fantastic court. It was just unbelievable.
Yeah, and you didn't think to say, well, listen, I actually, with the medal, there's someone else who was near it, and I was, you know, there's a bit of controversy over that. You kept that to yourself at the time.
Yeah, and so I went back to Freehills, and then I got a call from the 11th floor to say there's a half a room to share. Would you want to take it?
Well, I'm curious about.
What's this going? And my wife at the time had been Dean's associate.
Okay.
Incredible.
And
what was it like being an associate in those days?
It was fantastic.
Compared to it.
Oh,
I mean, would it be similar to how? I mean, they're all run so uniquely to.
Well, I was a chief's associate, and it wasn't as busy a court. It wasn't the kind of, I mean, notwithstanding what Supreme Court judges like to say, federal courts got busy. But, you know, those days it was smaller, much smaller number of judges, a much more restricted jurisdiction. But, you know, Nigel was the boss and, you know, he sat in a few cases, not too many, so it wasn't exactly overtaxing. But it was fantastic sitting, you know, I remember going down to Melbourne, sitting in front of them going, phew. You know, was a tax case and there was Bowen, Brennan and Dean.
Some pretty handy judicial minds there. But so we're now in the 1980s, the early 80s, and you're at the bar.
So I went to the bar because, and I went back home and said, well, you know, I'm going to do this one, you know. And Pamela, my wife, said, you want to go to the bar? You'll never get anything better than this. Take it.
Yeah, and she was right.
And so it never worked out whether that was, because it was Dean's old floor. Bowen was on 10, and it was either Bowen or Dean who'd sort of rang up and said, "One second, see if I've spoken."
And what was the bar like then? I mean, you're now a reader in 11 with some pretty formidable people.
Well, she first of all shared the room with Lindsay Foster.
Okay.
Then he took then he took the reader's room, and then who came in? Michael Pembroke.
Okay.
And Tony Marr came and went in the reader's room. So it was a very good floor. But what I hadn't known, what I came to learn, was that there'd been a bit of a fight on the floor about, because the owner of the room, George Masterman, wanted to let the room to another member of the floor as a room and a half. It was a big room and a half. And the floor decided it was getting a bit top heavy, and they wanted a couple more babies on the floor. And so the chairman of the board, who was a very strong-willed man, recently died in the last few years, Bob Hunter, forced them, because as you may know, if you have shares in that building, your shares mean nothing. You don't even get a right to it. You just shareholder in the company. It's all convention. And that floor was, the chairman of the floor ran the floor. And he said, "You're leasing it to these two." And he said, "How do I know they'll pay the rent?" He said, "I'll guarantee it."
Yeah.
So I did a lot of work with Bob Hunter.
Yeah, right. Well, that was a good, What was the bar like in the 80s, though, in terms of the people? Who were the sort of big names at that time that really...
Oh, well, Gleeson. And Gleeson took the job as Chief Justice in 88, I think. So, and there were silks like McCallery and Hunter. And
was Tom Hughes flying at that stage? Yeah, he was. That was his...
My word.
Yeah. Did you ever appear with him or against him?
Yeah, with him.
How did you find him?
Oh, he's a fantastic man. Fantastic man to work with.
What was his sort of strong suit, other than everything? But did he have...
Very loyal. He was very loyal. He was very hardworking. Prepared effectively and really, and he, like all good silks, they needed good juniors because they're busy, and but he was not only a gracious man, but super talented, terrifyingly talented.
Fierce cross-examiner, apparently.
We hear about all these personalities from the bar in the 80s and the 90s and even maybe the early 2000s, but are the personalities, the legends, are they dwindling, or is it just when you're in the era you don't really know who the legends are?
Look, there's a certain type of barrister whose skills are based around jury advocacy. That's dwindled, and they're left to defamation. Well, not in Victoria, because Victoria still had more juries than New South Wales. But there were some, and to have mentioned Peter Healing, he was fantastic. Vince Bruce and Peter Healing. But today, especially in Sydney, New South Wales, there's some pretty good barristers. Some terrifyingly good barristers.
But less sort of that perhaps opportunity for flourish that you got in those days, because there's less of those sort of trials.
Fewer of those trials.
Yeah. And did you, when you transitioned to being a judge in the federal court, were there things? What did you miss about the bar? Or were you quite happy to move over and leave it behind?
Yeah, I was quite happy to move it. I mean, it's a hard... those who do it understand what I mean. Actors would know what I mean. Not that being a barrister and being an actor, but the performance stress of the bar is really hard. And the older you get, the more you do it, the better you get, the harder it gets, because more is expected of you. Every time you improve, then more is expected of you. And you take silk, and more is expected of you. And it's how you... One of the great challenges of the bar that no one really tells you when you start is you've got to look after yourself in how you manage that kind of self-obsessed pressure, which you can't get around. You have to be obsessed. You have to worry about everything, because if you don't, something will jump out of the darkness and bite you on the backside.
Yeah.
And you'll lose the case and someone's life will be ruined and, you know, you've been paid this money or not and disaster struck because you were careless and you said, you know, it's all right. Yes, okay, let's have Sunday off. I'm pretty well prepared for Monday, but yeah, that'll do. No, it won't do. You finish, you know, you've got to worry till you walk in the door.
Yeah.
And people who are not doing it, and solicitors don't understand sometimes, I think, how draining and corrosive that kind of performance pressure is, or can be, and you've got to control it because that's what allows you to perform and work with 2 hours sleep 3 or 4 days in a row when you weren't prepared because you got the brief late.
So meanwhile, you're writing all these judgments, but it appears you're also writing judicially quite extensively. What sort of drove you? Did you feel that you wanted to say more than you could say in a judgment about broader issues in the law?
Well, you get invitations to speak, but at a certain point of time, I can't remember when it was, I think it was when I was on the Court of Appeal, I made a resolution that I'd limit what I did to things that would be actually useful in terms of recycling for so that I'm giving a talk on climate change and causation on Monday for my sins. But, you know, in 2010, I wrote a huge paper on causation in commercial law. And, you know, you then kind of full bottle on causation. And anything that might be said about it, that has been said about it.
So it was a process of learning for you?
It's a process of learning.
Learning, that's right.
Yeah, because the one thing you'd learn as a teacher is the best way of learning is to teach it.
Yeah.
Because, you know, and a lot of teachers, you know, one lesson plan ahead of the students when they're busy. And because I always taught at uni, I taught, there was a gap of 3 or 4 years in the 90s and I got a bit sick of it, but I taught at Sydney Uni and then University of Queensland, you know, from about 1981 to 2017 in various subjects. And you do learn a lot.
It feels like it just feels like you had something to say though about certain aspects of, and this will probably bring us around to this, the left-right brain and the ideas of values in the law, how they should be brought to bear in judicial decision making. And the book is arranged in a way where it sort of picks up on certain themes. But I've read a number of the papers, and there seems to be this theme that comes up all the time about the importance of how justice gets done really.
That's right.
And what a judge's real job is.
Yeah, well, there's a number of themes involved when I went to the bench. What's the thing that struck me most and early was the different task involved. And in a sense it's obvious, it's just you have to decide. But in a sense, it's I used to express it as the last paragraph. It's not the last paragraph, it's the next chapter. You have to resolve it. You have to work out which of these 2 bad arguments, which of these 2 good arguments, which of these, you know, and what's right. What do you mean? What are you actually doing? And I remember reading, sitting up in bed late one night, you know, with the light on, reading, and I was asked, you know, when are you going to turn the light off? And what are you doing? I said, I just sort of want to finish this chapter. And I was asked, what are you reading? And I said, Julius Stone, The Province and Function of Law. Said, what? Are you mad?
Yeah.
Why'd you write I said, this bloke's amazing. He was an academic his whole life. An academic, you know, jurisprudent, as it were. And he knows what we do. You know, he's reading it, and to try and work out what you're actually doing, you know, how you make decisions, how you think about principle, how you know, notions of categories of indeterminate reference and all that sort of thing. Yeah, and just thinking about what it is you're doing.
Yeah. Exactly, what it is you're doing.
What it is you're doing.
That's the thread, though, I took through, is that focal distance.
What are you doing when you're deciding your decisions?
Exactly. Yeah.
Because I mean, you from an outsider, from a reader, from a I think we would use this label earlier yesterday when we were talking off air for a little bit. I'm just a data miner. I'm going
exactly.
through.
That's the thing you do as a good barrister. Strip mines cases for ideas and puts the submission. And Peter Healy was a wonderful barrister. He was one of the most terrifying cross-examiner I ever saw, apart from Tom Hughes and Frank Montgomery. But I opened a book once, and it was Small's case, 1948, 47.
Commissioner Railway and Small.
It was a subpoena case. And he had blue highlighter and yellow highlighter, yellow and green or whatever. And they were obviously careful. And I said, well, what? He said, green is when I'm supporting a subpoena, yellow is when I'm attacking it. And I thought, wow, there you go. And that's what you do. That's what you do. And you do it by creating things.
Sure.
And it's one of the differences between the Sydney Bar and Melbourne. Melbourne, whatever Sydney barristers say about Melbourne, there's a greater sense of, you don't worry about what the other person's saying, you build a better thing. Whereas in New South Wales, the tendency was, if you can destroy the other argument, you must win.
Maybe we're more are we more left hemispheric?
I don't know, but that's what you do. Whereas a judge, one has to, and it depends what you're doing. And the beauty of the federal court, for a young
they have better
judge,
Wi-Fi, that's for one. But
well, you did both. You did both first instance and appeals. And first instance work is an act of creation.
Sure.
It's an act of creation. It's not like writing a novel, but it's recreating history from sources, oral sources, written sources. But you have to use imagination, not to make things up, but to put yourself there and try with that and work out what it was that happened. And it's a fascinating process of kind of empathetically, to a degree, kind of put yourself and work out what happened.
Why is that unique to the federal court?
No.
Or more more opportunity?
Because that's what you did at first instance.
I see.
And then on appeal, it's a post-mortem.
Okay.
And you're cutting up a dead body that's been done, and they say, now, appeals is by rehearing. We all know what that means. But it's not the same process as you do it on the paper. You get the transcript. And you go, you've got to find error. So what's the error? Judge found that. What's wrong with that? You don't go back and sort of forget
and create it all.
Start again. Take me through the evidence. I'm not interested in what the judge said. That's what a lot of civilian countries do. And then they have that distinction that it goes on a final appeal to a court de cassation, a cassation.
As a first instance judge, though, are you creating? I mean, when I was a tipstaff to a Supreme Court judge, George Palmer, his sort of mantra to me was, what I discerned was, look at the justice of the case and work backwards. Not necessarily applies to all.
You've got to be careful. I mean, that's right. I mean, but
I don't want to do him a disservice in saying that. But what I'm saying is that's kind of what I detected.
The person one of the people who I sat with in the Court of Appeal, and who kind of, as a baby, he'd become a baby judge just as I was around about the time that I became a baby barrister. It was David Hodgson, and he was very hugely intelligent, hugely intelligent. Used to write books on philosophy, published by Oxford on the train to and from work, from Burwood, kind of thing. You did, and have a little nap in the lunchtime, and do more work. About the only person who did more judgments than David Hodgson was John Baston.
Right.
Who worked twice the number of hours on it. But, he was a mere mortal compared to David. But Hodgson, was a very, always looked for the kind of justice of the case, but never, ever could you ever see him bending any principle or being intellectually dishonest.
You've got to be faithful to the principles.
Well, that notion of intellectual honesty is, but there's another expression which some lawyers kind of wince at when you say it, but the law oozes out of the facts in most cases. The law oozes out of the facts. And if you understand the facts and you understand what happens, there's generally not too much law involved. And very rarely does the law bring about an unjust result if you understand what happened.
The law falls in with the facts.
The law falls in with that. I mean, this whole debate about unconscionability that we've been having because some people have such difficulty with it, it falls out of the facts. And ordinary people, business people, ordinary people understand the difference because they can feel it. It's an It's partly and I'm getting onto McGilchrist later, but it's partly there's an emotion. Emotion isn't getting teary about something or getting angry, although anger is a left hemisphere response. People know the difference of a hard bargain and sharp practice.
Sure,
they do. Exactly. It generally comes in one word. Their response to what happened, and so those sense of that oozes out of the facts, and I remember some of the cases in the Court of Appeal which were just, once you understand exactly what happened, you can say, well, that just should never have happened. And if it's an equity court, you apply principle, and the whole humanity, in a sense, the book has been launched in a couple of days, about a week. If you understand equity, that's where it comes from. And in common law as well, but equity is where the sense...
A great example is that what you write about unjust enrichment and restitutionary principles and the labels and the...
All these labels. I mean, Burke was a German, a great scholar.
Yes.
But I never... Gummo fought on the barricades for this, and he and others, but he in particular made sure that that equity's place in this was to be recognised, because restitutionary notions run through equity as much as anything.
But these are all community values, aren't they?
Yeah, exactly.
Ultimately, and that's the judge's role in these cases, often these marginal cases where you're interpreting.
And that's why, as you become a judge and you're trying to work out, you've been as good a place as province and function of law to start reading is to go and read some biographies of people such as Cardozo and Holmes and Dixon, and understand them, and then read their cases. And
I've got a good Holmes quote here that from one of your pieces in the book, from the case of Lochner, which is the bakery employees case, the American case, and he says, general propositions do not decide concrete cases.
Exactly.
The decision will depend on a judgment or intuition more subtle than any articulate major premise.
Exactly.
And this idea, again, that there's just so much more going on than the rule
It's
itself.
about life.
Yeah.
There's social rules. The law is about the social and societal rules that we organise ourselves by.
And it's not necessarily the individual fixed on the individual. It's also the community and what the community expects.
That's right.
But that's what the judge brings to bear, and that's where the judge has to separate him or herself from
that's
her own.
But that's why I've said it a couple of times, that there's this kind of antinomy or opposite that bound up together. The judge is a manifestation of just state power. So you're abstracted. But it's only worth seeing done if it's done in a human way. So yes, you're an abstraction. And I said this to us, I won't say who it was a Supreme Court judge who was presiding over a murder trial, and the man was convicted, and the judge was very upset because the judge thought that he was guilty of manslaughter. He knifed someone and they died. He was a bouncer in a brothel or something. But he was of almost, sort of childlike intelligence and whatever but it was manslaughter, but they'd convicted him of murder, and so he was, wasn't going to be below 20 on the bottom. And this judge was deeply, deeply upset and wasn't sure whether, I'll use the word they, so gender's not they, would be able to do it. And I just said, you just got to, you're the manifestation of just state power. You've just got to remove yourself and abstract yourself and do it. But at the same time, and that kind of allowed it to be done. But at the same time, it's got to be seen as a human response, and that's why the fallibility of the judge, but the abstraction as the agent of a state power, but doing it in a way that's civil and polite and human, not necessarily
and
polite, connected back to them. So you've actually there's this kind of antinomy, and that's why I remember in circumstances where there was I suppose I can say this without committing a criminal offence. There was a complaint when I was on the Judicial Commission of a magistrate who had sentenced a man with very limited education he was a violent man, and he'd bashed his partner yet again and was getting a serious sentence. But the magistrate said something to the effect, but what I really should do is get that sergeant out there and take you out the back and give you the thrashing that you gave her.
Right.
And he made and the offender from prison made a complaint. And he said, that's not how, and it was kind of this living embodiment of this man understood this is not something that person as the manifestation of just state power should ever have said to him.
Sure.
And he was offended by it.
Sure.
He said, I'm not asking but I was offended to be spoken to like that. And it was what's your right to be offended? And you think, well, he has it because he's being sentenced and he's got an entitlement to be sentenced properly as he was.
And treated
with
dignity.
He's entitled to that dignity, even being sentenced for what he did.
Sentencing's a big thing. We
it's fascinating.
But just sorry, if I could just tell an example, again, I'm going to reference George Palmer again for a moment. When I was sitting with him, he sentenced an individual for contempt, and he sentenced him to something like 6 months. But we, in chambers, the beauty of being an associate is getting to talk to the judge about it. And when he was delivering his reasons, which he clearly felt a great deal of sympathy for this particular offender because he had particular subjectives that were just beyond, I don't need to mention them here, but they were very, very difficult circumstances. But he knew that there was no alternative, being intellectually honest and faithful to the principles that he had to sentence him. But His Honour had tears whilst he was sentencing him. I just remembered that when you said you just got to hold up and be the symbol of state power of the state.
Yeah. But that's what it is. It's an embodiment of abstraction and humanity. Because if you're just an abstraction, it's you can't. And we had all these debates, during the pandemic about sentencing people on the video link,
Right.
And one of the things I gather now that when I was in the Court of Appeal, sitting in the Court of Criminal Appeal, hadn't been changed, and the prisoner had a statutory right to be present at his appeal.
Okay.
Generally is. And so they were always brought in, so that big van used to come in full of CCA matters.
But you're right, sentencing is, because the response of that is so subjective.
It really brings together a lot of the things that we're talking about and you've been talking about in this context of the importance of the right brain, the right hemisphere of the brain, particularly in circumstances where there are guideline judgments or what have you, in bringing this intuitive synthesis
that whole story is so interesting, and it might be worth saying at this point that what I became interested in, Kevin Connor, who is a mutual friend of the three of us, I think.
He's a good friend of the show we mentioned earlier.
Yeah.
Great bloke.
Was shoving this book under my nose for about 6 months. I said, what, Kevin? Just read this. And it was, Iain McGilchrist on Master and His Emissary. Now, McGilchrist is he's one of the great thinkers of the 20th and 21st centuries. That has to be said. He started off, he was a scholarship boy at Winchester, which I'm told, I don't know the rankings of English public schools, but apparently that's pretty good.
It's up there.
And he went to Oxford and said, I want to do a PhD in religion. And they said, well, you can't do a PhD in religion. There's no PhDs in religion. But why you want to do religion? You want to be a minister? He said, no, of course not. But I'm interested in religion. So, well, you can't do a PhD. I said, no. And they said, well, why don't you do philosophy? He said, English analytical philosophy. I'm not going to read that stuff. I've read all that stuff, don't like it. He said, well, I suppose I like. And they said, what about literature? I said, yeah, okay, literature. So he became an Oxford. He did his, and he became a don. He was teaching English literature and became fascinated. His first book was a book called On Criticism, which if you ever find it, sort of try and buy it because I can't find it. But it's his first. And he was fascinated, absolutely became completely fascinated by the inability of language to say important things, and in his first expression of the matter, the limits of text. It's an expression I've used and always, and it's from Ian. And so, like all good polymaths, he decided, and he's thrice elected to is it All Souls? No,
I think was it All Souls? I think
thrice elected. That the college where there's no students, you just get a scholarship to go and think. It's probably destroyed more people than. But he was elected 3 times to this over the years. And so what he did was, like all polymaths, he decided, well, he'd better study medicine to work out why this is the case. Of course. So, and he became a practicing psychiatrist and managed to, and was a senior, and studied neuroscience and studied in America and worked and studied in America. And then began writing this book. It was published in 2009 and it took about 10 years to write. The Master and His Emissary, which is a story, I forget where it originated, but the Master is a great man who understands, rules all this great land and has emissaries, dealing with particular places.
Right.
And the emissary says, it's all this, I can do this. Well, this is not so hard, So the emissary imprisons the Master and takes over, and it all goes pear-shaped and horribly wrong and
I think
falls
tell
apart.
You the Master and which side's the Master and the Emissary now.
Yeah, he got the whole, but and what he and he was involved in split brain, so sort of during the development of split brain surgery that they often used on people with bipolar disorder and huge kind of, which are very often. Well, anyway, I'm not a doctor, so I won't. But this book, it's called Master and His Emissary: The Making of the Western World. So it's a potted history of the West. He's not a historian, but he's kind of read, polymathically. And there's 50 pages on the brain, so you kind of work out, and the corpus callosum. Mm-hmm. And the brain has two halves, and it's connected by the corpus callosum, which is not a transmission, it's an inhibiting. So there used to be a theory, which is all bunk, that women were right hemisphere and men were left, and the right hemisphere does some things and left hemisphere does other things, and they do work different. Both actually are engaged in almost every function. And what the left hemisphere does is it breaks everything up into little pieces. It analyses, breaks it down, taxonomises, and the right hemisphere is to do with relationships and reality and seeing, and the two together, essentially together, analyse, but then in the left, and analyse and then put it back into into the right hemisphere to see what its context, its importance, and where it fits in, and the shape and the meaning of what's going on. And so you need both hemispheres working, and autism is generally, I gather from reading his work, is a product of a right hemisphere deficit.
I see. That
it's just, and you see those autistic kind of people, those children who, what day was the 7th of April in 1544? It's a Thursday.
Yeah. Right.
That kind of
left.
Yeah. That and people who do that, and you say, well, it wouldn't be dead for quids, and they don't know what you're talking about because it's a meaningless expression.
Sure.
Yeah.
But it's entirely contextual. Things are going bad. Bullets are flying. Or this, some judge is just tearing you apart, and you sort of say, "You wouldn't be dead for quids."
Yeah.
And it means nothing, but contextually, it's a statement.
How far into it were you, into being a judge?
So
how many years had you been a judge before you read this?
This?
Yeah, this book.
This was 2013, Kevin, and I read it in 2014.
And you also brought.
And I thought,
that's
the first part, the brain. The next 200 pages is a discussion of literature, music, dance, poetry, psychology, psychiatry, philosophy, not law, history, music, not law. And I'm sitting there just reading, just annotating and underlining, because it's all the things. What's the difference between, I'm not being disrespectful, I'll make some comparisons, and I'm not intending to be disrespectful. But what's the difference between the way Mary Gaudron or Bill Dean, Sir William Dean, would approach a problem and Ken Hayne? All those judges who go, and you look at Margam and Lehane, you can tell who wrote some of the chapters, because some of the chapters are colony line A, colony line B, colony line C. Others, it's just, it's a whole thing. And they approach things with a different, and you see it in your colleagues. And they say, and when you say, well, it's what is this unconscionability? I mean, go back to that, because it's just driven me mad over there. I mean, it's because they're not equity lawyers, and they don't, come on, just think about it. And people criticise me for kind of writing the extent I did in Pachoka. I said, look, it was my only chance to try and explain what it is. And yes, I could have put it in half or a third of the space. But, you know, there were people there. I'm dealing with colleagues who are tearing their hair out because there's no definition of unconscionability. And you say to them, it's not a definition. And they go, well, if it's not a definition, how can you apply it? And you go, let's start again.
Yeah.
Let's talk about values and, values, don't get all that. That's
I need
all
a checklist.
I need a check. I need a test.
I need to know.
I need a test.
Yes.
I need a test.
I need a formula.
How many parts are there? This is the left hemisphere just saying.
What's the second limb?
What's the second limb? What's the? This is not a second limb case. You told me this was a second limb case. This is a first limb case. Therefore, you
There are
lose.
limbs in Margamo Lane, so there must be probably.
You think, what are you talking about? Are you serious? And one judge in Melbourne once said to me, equity is a fiction of the New South Wales, is a figment of the imagination of the New South Wales Bar. And he was judge, the federal court.
Wow.
And I said to him, that's the most shocking thing I've ever heard anyone say. And you need to understand that, you know, that's terrible. Every legal system in the world has a notion of equity. It might be disguised, it might be...
Can I ask you about the maxim equity follows the law?
Yeah, that's right.
And it was written by a few heavy hitters too.
What's the... I mean, should it? Does equity follow the law?
Yeah, well, it follows it follows the law, and it's. I mean, if that's.
is it necessary to follow the law if the law is
Well, should it be
value-based?
the other way around?
Well, it depends on.
Well,
it's exclusive,
Chicken and egg,
jurisdiction or concurrent, or you know.
Yeah.
It's a nice segue, I think, into legal unreasonableness, James.
But can I say
legal
unreasonableness because legal unreasonableness. You said you got 51 in admin. I'm prepared to say that I got 61 in admin, and I hated it, and it was one of my worst marks. And I hated it because I couldn't understand it at all. I was told the 6th criteria in Craig, and even when I came to the bar, I was laughing with Nick earlier when we came to the bar as a baby barrister reader. And a lot of the work that I wanted to do was in the public law and migration space. I'm looking at these visa decisions. Got Craig next to me. I'm going through the list and I just can't find error because I'm going, well, you took into account irrelevant consideration. Oh, but geez, it's all, no merit here. Oh, what do I do? And I just never knew. I was just so daunted by running public law cases because of it. But I feel as though, and legal unreasonableness is maybe a different category, but the jurisprudence seems to have been seems to have moved in a different direction in the last decade.
Oh yeah, it has. When the special leave SZRKT,
yeah,
it was the judge, Robertson judge.
Yeah,
that was he set aside.
I'm too right hemispheric to remember judges' names.
Yeah, he set aside a decision on credit in the tribunal as legally unreasonable, as arbitrary and legally unreasonable. And it was just as I got back to the federal court. He was writing it as I was there in the first week or so, and he and I talked about it as he was writing it. And back in the day, of 7 years previously, 6 years previously, that would have lasted 5 minutes, and the appeal would have been dismissed. You know, the application would have been dismissed. It's a question of fact. You know, and it's all about credit. No,
too far into the merits.
Too far into the merits, and it went up for a special leave application. I remember. The High Court judges said, "There's nothing new here." Boom, and I thought, "Ooh, This was Before Lee, L.I.
Yeah.
And they were right. They were writing Lee, I think.
Right. Okay.
And I thought, ooh, what's going on here? And then Lee came out.
2013.
Yeah.
2013, later in the year.
Yeah.
And ooh, well, brave new world.
Sure.
And they said, no, nothing new. And that's the one complaint about ultimate courts of appeal. I won't say the High Court. when they don't say what they're doing, there's nothing new here. Right? And everyone goes, oh, yes.
Was that like nothing to see here?
Nothing to see here.
Star Wars
nothing to see here.
Yeah.
Or this is, and you think, well, hang on.
Because at that stage,
from 2013 it started.
If you want to touch unreasonableness at that stage, you're left with illogicality, irrationality, arbitrary, capricious decision making. You're looking at no fat, no evidence grounds, or Wednesbury unreasonableness, and you're looking at these labels and trying to find, and you go anywhere near the decision without looking at the context and purpose the way you've articulated it.
Well, that was Stretton in
Stretton in 2016.
Yeah, well, Stretton was just trying to pull it all together for the reader.
Yeah, and I think that made it.
And then applied in the Djokovic decision, which was.
Oh, well, that was pretty easy.
It did strike me as easy. Reading the reasons, I just thought, this is all. It was a very serious.
It was a very serious, and I thought
I'm not seeking to.
I won't. It wasn't placed into a judgment, but that's something to be explained off camera. But everything that based the minister's decision had been known for months.
Yeah, and that was
before he was given his visa.
Brings us around to the whole right brain side of it again, and the value about community values, and where it's interpreting the decision and whether it was legally unreasonable. And that's what Mr. Djokovic.
This for our audience is the Novak Djokovic.
Novak Djokovic sought to argue that his visa cancellation was legally unreasonable, and you, the full court, ultimately including yourself, Justice Bosanko,
and O'Callaghan,
made a decision that, of course, that the minister's decision was
in a sense
made.
Yeah, and it kind of turned on a discussion we had with counsel, who did a very good job. All the counsel did a really good job in that case, because it was a pretty hard case. Because, as I said, Minister knew all those facts before he got his visa, and they knew them from, and they knew he was coming, and they knew he was an anti-vaxxer, as it were, if I use that expression without disrespect to Mr. Djokovic. What they didn't know, I suspect, is where public opinion lay.
This is the bit that I find interesting in terms of
anyway. That wasn't run. It was not run as a bad faith case, and I'm not saying it was bad faith, but that's what it was hard on the man, because he got his visa, everyone knew everything, and then the decision's made. But the reality was, when we were arguing it. That it was being argued before us, and we said, well, a lot of people look up to someone like this.
Exactly.
Yep. And that was the value. That was the community value.
This is the community value. This is the quote I wanted to raise. The themes of encouragement and emulation of a sporting hero and icon run through the reasons for satisfaction as to health and good order and the public interest. And health and good order, the good order and the public interest. I mean, that was the test. Effectively,
there's a lot of things being said at the moment about the wrong way of approaching the pandemic that are constructed with so much hindsight. It's almost laughable sometimes. Now, I'm not saying that there was approaches made to the whole period of the pandemic that I thought at the time were very wrong, not allowing Australian citizens to come back to Australia. Was kind of like, just couldn't believe
incredibly
it.
Harsh.
I could not believe it. Almost vacating of the field of Commonwealth power and leaving it to, when they had the quarantine power, leaving it to the states, and the way some of the state leadership were dealing with the matter. But you have to remember that when this started, nurses and orderlies in Milan and Italy were deciding on the street who lived and who died.
Absolutely.
Because they didn't have a number of beds. This was, and no one really knew
the death toll
what
over Europe
this
every night was
could do. And there's a lot of recreation with benefit of hindsight that, we didn't have a vaccine for, and whether that vaccine had worked or whether the... Anyway, so, to talk about public health and public order was hardly fanciful.
And you at that time were the barometers of those values and the custodians of those values, in a sense, in bringing to bear that on this decision.
So you wrote Stretton in 2016 after having read Iain McGilchrist's book.
Yeah.
When you were reading Iain McGilchrist's book, did it resonate with you, or specifically the it resonated because you had these sort of
exactly
values?
No, it explained to me. So let me go back to the book. So the 50 pages in the brain, 200 pages about music, dance, and then about 200 pages from the Greeks to the present day, showing how different the notion of a societal way of thinking, and that they're only, and the Renaissance and the Greeks, this kind of beautiful, synthesis of the left and right hemisphere of the way, and then coming, and with a late efflorescence in the romantics of the 19th century. But he sees, and it's, people have to sort of sit up and go, "Ooh, hang on a minute, there might be," that the Enlightenment and the scientific Enlightenment from the 18th century onwards is where we're careering down a path of, not that I'm particularly religious, but of rejecting things such as religion and the indefinable, evidence-based medicine. Well, what about intuition? Well, no, can't have that.
Sure.
And that's where, he's written another 2-volume masterpiece since Master and His Emissary, which I haven't got time to talk about, but and it's really moving into philosophy. But he sees the result of Western left hemispheric thinking is driving us to destruction.
Which is what he's saying presently. There's speeches I've read of his more recently where he's
using the world as a resource, and that's what we have done.
And in the context of AI, it becomes a doomsday, terrifying picture, and one that's not beyond the realms of possibility. But these were things that I got to get the sense that they were things that you already maybe intuitively knew and believed, and then articulated them, and you resonated
and
with you
slowly, Sandy and I stayed with him in Scotland for a couple of nights. We've got to know him.
Did you just ring him up and say, I'm...
Well, Kevin and I just sent him, we found an email, we wrote it, and he said, and he responded, and it was fantastic.
You brought him to Sydney to speak to the judges.
I brought him to Sydney to speak to the judges.
Yeah.
I thought it was that important. And it was an interesting judges meeting. And it was the judge who said equity is a figment of the New South Wales Bar's imagination.
This was a little controversial, what you were doing.
Yeah. Well, we always try to have him, but it was, spending public money. But we defrayed it by, we kept him here for 2 weeks, and Kevin got him digs at St John's and things like that. And he went down to Melbourne, and anyway. So he talked about, his standard stock stump speech about left and right hemisphere. And this judge, who's really, I won't say who it is, but he's a really smart man, but he's really it's just always the left hemisphere working. And he has great difficulty with context. And I said, we still have some time for questions. And so this judge stood up and said, all right, that's all very interesting. It was kind of quite rude, but he didn't realise he was being rude. That's sort of problem with Bolton. What advice have you got for us as judges?
After the talk?
Yeah, it was after the talk. Exactly. And Ian said to me later, I said, that was really rude. He said, no, don't worry about that. He said, that's what I get asked all the time. And he's ready. And he said, you know, what advice have you got for us then? And he said, 2 things. Understand why you're answering the question.
Yeah.
And second, more importantly, when to stop writing.
Now,
And bless his cotton socks, this judge looked at him and went, thank you, and sat down. He realised, you know, what the import of the answer was, and he got it.
now I can't let the moment pass, and we can edit this if we have to.
Sorry,
but have you got a view on direct speech and affidavits?
can we, before we go into
No,
that,
let's talk about that.
can I just ask you? There's a great little anecdote in your book by with a colleague of yours had an artwork in his chambers that said the world is ruled by language, and you would always say to him, but understood by context.
Yeah,
Sure.
And he went back to the artist, and she went, ooh, wow.
This is looking like a diptych.
Yeah, that's David O'Callaghan.
Yeah, that exactly. I didn't want to name it. Well, he's named in the book. I mean, it's not. Sorry. I wanted to talk about sentencing.
Sure.
Do you want to talk? Yeah.
No.
Can we go on to sentencing just because I just think it's a fascinating part of it. We touched on it earlier, but you've described it as being experientially intuitive at heart. And I know that that's something we sort of have already spoken about somewhat, but you also recount having read the decision of Veen, the High Court's decision
Veen
number 2, and that it had a deep effect on you as a judge. Could you just explain that?
I was only talking to someone about it today, one of the young kids in the office who are paralegals and stuff. It's one of the most remarkable bits of writing. When they all, I forget how many judgments there are, but the judgment, the majority involved Mason and others. And Dean wrote a dissent. Was it Mary Gordon in it? I think, I'm not sure.
What were the facts, James?
I'll come to, and it was the facts were these. Mr. Veen had the life that makes you shudder when you have children. He is an Aboriginal man. He was an alcoholic by the time he was about 10. He's a drug addict by the time he was about 12 or 13. He's a homosexual prostitute on the wall at Darlinghurst in his teens. And he had a mental disorder in the sense that he, upon getting angry or getting drunk, or he could lose all control completely. And he murdered, or he killed rather, a man, a client, who racially abused him after finishing the transaction, if I may use that expression. Refused to pay him, told him to F off, and called him all the names under the sun. So he killed him, and he stabbed him about 100 times. In a kind of furious rage. He was then sentenced by the sentencing judge, to never be released because he was such a danger to the community. The Court of Criminal Appeal dismissed the appeal. This is Veen number 1. And the High Court, by majority, I think, in Veen number 1, well, Veen's case, first case, overturned it, saying, no, you can't do this. Can't do this. It's preventative detention. You can't do this. So they sent him back, and he finished his sentence in, I forget how many years he did, 10 or, and within a year, almost the identical thing happened. Identical thing happened.
Yeah, extraordinary.
And by majority, the court wrote a judgment and said that they dismissed the appeal. Again, it was from the.
He got manslaughter though, didn't he?
Yeah, he got manslaughter. He got diminished responsibility in both times. Yeah. But still,
But the evidence was better on the second time.
Yeah, and Dean's judgment was this is preventative detention and you have to have a statute, which led to the statutes, you know, leave aside the missteps in cable that led to Forge, Tick, and even that one in Western Australia, we can do it now for stop naughty boys stealing. But the whole judgment, the Mason's, the majority judgment is a tour de force of how it's just said with this subtle, simple but engaged and sympathetic strength to saying that it's not logical, but sometimes you have to. Yes, he's less morally culpable because of his circumstances, but that does not mean the sentence is lighter.
Yeah, exactly. Because he got
when you read it, you realise what they're really talking about is that some people, if you don't give some people a just, in the sense of harsh sentence, the community loses faith in
community
the protective
values back into the same.
Whereas
notion.
Dean in particular was saying this is, and they said we're not doing it for preventative, it's taking into account all those things and giving the right sentence. And Dean said, no, what this is preventative detention and you do not have power to do it.
I'll just read to you this paragraph, I think, paragraph 9. The protection of the community obviously warrants the introduction of some acceptable statutory system of preventive restraint to deal with a case of a person who has been convicted of a violent crime, who, while not legally insane, might represent a grave threat to the safety of other people. And then they go on to say such a system could, one would hope, avoid the disadvantages of indeterminate prison sentences, but then go on to explain that, that was...
But it was a kind of masterpiece. Of, who was in it?
So
the majority.
The majority was
Mason.
Chief Justice Mason, Brennan, Dawson, and Toohey.
Yeah.
And Justice Gordon wrote separately, it looks like.
And Dean wrote separately.
Oh, right. I haven't got to Dean's judgment. My apologies.
But it really hits on the subtlety, the nuance and the humanness, if you like, of sentencing and where the right brain comes in.
And Wong is an interesting case because the one thing you can't accuse Chief Justice Gleeson or Chief Justice Spiegelman of being is kind of left hemisphere and limited. I mean, they're both hugely whole in their thinking, with terrifyingly efficient computers in there, but at the same time, they always understood what the focal distance was and what the question was. But they each had a view that a degree of framework in sentencing and grid, without being too rigid, was a good thing. Whereas the majority of the High Court said, no, this is too... And it's a great judgment. And Wong's a great judgment too.
Because Chief Justice Gleeson was in the minority.
In the minority,
in that case, yes.
And Justice Gummow and others were in the majority.
Do you have anything to say about... because one of the things about sentencing is the tension between sentencing judges and the community expectations and how it's sort of presented in the public, and you sort of hear the radio announcers talk and criticise and express, aghast.
Well, they don't have to do it. They don't have to destroy the life.
Yeah.
And the CCO was, because I'd done a bit of crime in the early years, but not serious crime. And sitting in crime, you always had to preside, unless you sat with a chief, which would have been a 5-judge bench, which I did a couple of times. But sort of in the run-of-the-mill CCOs that you're sitting on, he presided, and it was hugely. To call it interesting is sounds awful, but it opened my eyes to realise that how you're not a whole. You can't really say that you're a whole lawyer and a whole judge. if you haven't had to deal with the kind of difficult decisions you have to make in criminal cases.
Okay. Now on to another area that I wanted to ask you about. One of my favourite decisions of yours, going back when you were the President of the Court of Appeal, was Caltex Refineries salient features.
Stavar.
Yeah, Stavar. Yeah. Because, you know, as a lover of tests when you're young at the young in law and just wanting to work out.
Can you refresh me on the salient features test?
You need to examine the salient features of these relationships.
Why am I asking you actually? That's what I should ask.
Well, Stavar was it was
that's all right.
It was.
I mean, I could do a good job of it.
It was his wife.
Yeah.
It was Mr. Stavar's wife. He worked at the Caltex refinery and worked with asbestos lagging.
Right.
And the case was about her, in my recollection, because she washed all his clothes, and she got mesothelioma. And this was at a time kind of pre McGilchrist enlightenment, as it were.
But already already bubbling away in your brain.
Already bubbling away, but I wrote Stavar, and I remember who was my associate. It was Anna Garcia, I think, or I think it might have been Anna. And I was reading all these High Court cases, and I was kind of kept trying to look for the major premise, you know, and I thought this is just. Can't they do better than this?
Because at that point,
and then I thought I'm going to make fun of it. I'm just going to make fun of it.
Come out at that stage.
I think it was.
And I thought I'll just make fun of it. I'm going to go through them all. I'll draw a list up and see how silly it looks. But it didn't look silly. It was, and I kind of go, oh, I get it. You know,
there's a thread,
and there's a thread, and there's the list there of all the factors, not exhaustive, obviously.
Yeah.
And everyone said, "Oh, this is helpful." And I thought, well, actually, I was doing it to almost be
cynical.
Cynical about it.
Negligence, of course.
But that was with one of the proximity tests.
Was it proximity?
Well,
at that point. I mean,
proximity was Stephen and Caltex and Sir William Dean, and it was destroyed by the High Court as. And I think there was a bit of a campaign to get rid of it. But it wasn't a bad start.
Yeah.
That notions of physical and spatial and other forms of social proximity was really what a sense of close, and that's what they said in Caltex.
Yep.
A sense of, you know, and it's not definable. And I think there's one or two in particular High Court judges wanted to destroy it, which they did successfully. But it did give you a kind of, well, what are we really looking for? Sufficient proximity to make it, and this was what has always been, sufficient proximity to make it, looking at all the circumstances, legally, not just legally appropriate, but making it just legally right to impose a duty that could lead to liability for breach.
Sits cosily alongside foreseeability.
Because you have to have some, I've looked at all the things sitting on this desk, but how do I decide whether it's
which one's
enough,
in the circle and which one,
who's in the circle and who's not?
Yeah.
And they did a pretty good job in Woolcock in those cases on economic loss. You know, is there any reliance? There's no reliance if there's no... But that notion of proximity that's, I think it was Stephen in Caltex and Dean in a number of cases.
That was the dredge.
The dredge Willemstad, good old West Ham dredging.
Yeah. I was like saying that, the dredge.
Is the notion that, you know, you're sufficiently close, either in space, in time, in circumstance, in social obligation, etc. Now, how is proximity kind of found? Well, look at all the circumstances.
But I detected.
You had your list.
Yeah,
Sorry,
but no, I detected that there was you were looking for it was principled based approach. You were cataloguing.
Is that why you said this is pre-Gilchrist?
Well, no, I said it's bubbling away clearly, and then you've got Gilchrist, and then you've got Stredden.
But there is something that hasn't that was like sort of absent. I won't say absent in some of those cases. And having ditch proximity, they had a difficulty in expressing, other than look at all the salient features and then impose the duty. And said, well, why will you be imposing the duty? Because it must be, because having looked at all those circumstances, it's just and proper that this person is held by the law to owe a duty of care to these people in those circumstances.
Now, before we leave the cases, and I'm conscious that we've taken a lot of time, and we should let perhaps not let him keep him too far. It would be remiss of me not to talk about hands. I mean, hands has become a little bit of a cliche, but it's also really important, I think, and I think a lot of people have latched onto it because of what you wrote about.
A couple of judges in the High Court went out of their way to say it was wrong, footnoting it in relation to propositions it didn't stand for, but I'm not sure it still survives.
Well, we'll be intellectually honest to it and acknowledge that, but for the dreamers and the people that took a lot from it, can I just read a bit of the passage? This is paragraph 3, and it's in the context of a decision to cancel a visa on the basis that a visa holder has failed the character test.
Hands from New Zealand?
Yeah, New Zealand.
Yeah.
And there was the decision in that case involved the minister saying that the New Zealand visa holder, the visa holder would have little to no difficulty in resettling in New Zealand because notwithstanding his strong, significant ties to Australia, including all his family, and the error that was focused on.
Well, there was an easy error that we got rid of it, but I decided to write paragraph 3 anyway.
By way of preliminary comment, well, it's just a comment really then, isn't it? It can be said that cases under Section 501 and the question of the consequences of a failure to pass the character test not infrequently raise important questions about the exercise of executive power. Among the reasons for this importance are the human consequences removal from Australia can bring about. Public power, the source of which is in statute, must conform to the requirements of its statutory source and to the limitations imposed by the requirement of legality. Legality in this context takes its form and shape from the term, scope and policy of the statute and fundamental values anchored in the common law. You then go on to say the consequences of these considerations are that where decisions might have devastating consequences visited upon people, the obligation of real consideration of the circumstances of the people affected must be approached by confronting what is being done to people. The obligation and the expression of its performance is not a place for decisional checklists or formulaic expression. 2018.
Oh, you've definitely read McGilchrist by then. Yeah.
But the last sentence of the last 2 sentences of the paragraph are important.
Sure. Mechanical formulaic expression and pre-digested shorthand expressions may hide a lack of the necessary reflection upon the whole consideration of the human consequences involved. Genuine consideration of the human consequences demands honest confrontation of what is being done to people. Such considerations do not detract from, indeed they reinforce the recognition in an assessment of legality that those entrusted with such responsibility be given the freedom of lawful decision-making required by the Parliament. So you're not taking away from the freedom of executive decision-making.
And you see, what I was attempting to do is speak not to ministers, but speak to the people who did the draft reasons.
The draft reasons.
Yeah.
Yeah. Oh, for the of course for the
Yes.
because the minister just ticks them and signs them.
Well, no, I wouldn't
Sorry,
say that.
sorry, I
no,
wasn't
no,
sure
no, no. So that when, okay, what have we got today? We've got 4 501s. Okay, the paper's prepared. Yeah, and you wouldn't expect the minister to say, well, here's the file, minister. Go for your life. I'll come back in a couple of days to see how you're going with those 4 files. Exactly. He's got a lot of things. He or she's got a lot of things to do, and it's perfectly proper for the department, officers in the department, to look at this and say, well, look, I've looked at it. You may or may not agree with it, but I've done a draft and there's a yes and a no at the bottom, and I've tried to go through everything, and there it is for you. And I can't tell them what to write, and no judge can tell them what to write. But if you say you've got to confront what you're doing, that's what genuine consideration is. Then it may well be that what the minister is then given has a degree of the reflection of that genuine engagement, which is and if the minister wants to still make the decision,
then they can.
Then they can.
That's the freedom. So don't gloss over it.
But don't just say, I've looked at, I've looked at.
Operating in a vacuum.
You're not just ticking off things that, you have to look, well, what's this going to, this. I mean, his history was quite interesting.
Because it's wrong to take that too far. What you said.
Of course.
It's not a license.
And the courts can't say you can't do this because it's awful. Because at about the same time, there's Stretton. Yeah. Well, no, Stretton was the one where we let him through. He was the
16.
He was the person who was the grandfather who thought it good to. Or he's a great uncle, I think, to play with his little great grand niece on his lap, and one of the trial judge said, no, I think this is unreasonable to kick him out for this. And we said, that's not the test. It's not you think it's reasonable. It's, could the minister have thought this was a proper decision?
Right.
And we said, you bet.
Yeah.
So it's
community values.
But and anyway, I forget the case. And the hands in some of the judgments was disapproved. But it's what I thought, and I still think that it's not if it's a serious decision, it's not a genuine consideration just to mouth platitudes about the subject.
Face what you're doing.
There's a great humanity in that passage, James, I must say.
But I think that's like for
touching.
For like, for admin lawyers and some of the admin law work that I've done.
And that's why admin law is actually, it is constitutional law.
Absolutely.
And it's interesting.
And I tell people who come into my chambers now as associates and paralegals who are doing admin law, and I said, look, if I could give you one piece of advice, tune into admin law. Because I didn't get it.
It's about power.
I didn't get it in university, and it touches everything.
And the laws about, declaring rights, obligations, but it's about protection. It's the only power that's truly protective, as opposed to an exercise of will.
Of the weaker party.
Well, not necessarily the weaker party, of everyone, of the individuals, whether they're weaker or stronger, and of the group and of society.
But often they are when the state is making a decision
they may be
like that, and this is a person who's changes their whole life.
But it's not just helping the weak. It's protecting people's rights, holding people to their obligation, and doing all the things that a judge has to do for the benefit of individuals, the group and the society.
Touch on this briefly before
we just wanted to touch on the idea of courts as workplaces and this notion of bullying, another label. Yeah. And again, it is ill-defined. But
in one of our first episodes, we read a passage from... Do you have it?
This one.
Oh, well done. prepared as always.
Did you want to? Is there a particular?
There was just the one.
There's a bit of it that I was interested in, but not especially. It says there's a part that says this is something that an extract from a presentation you gave courts as institutions and workplaces in a conference, a joint Federal Court Supreme Court conference in 2019 Hobart. And it says, if judges are polite and civil, the alpha male instincts of some barristers will be curbed. I thought that was a really interesting comment. What did you sort of mean by that? Setting an example, or?
Yeah, I think setting an example, and also the one thing a lot of female barristers find objectionable is the continuation of the kind of clubby, aggressive behaviour of a lot of men, and it's not, you know, a kind of gladiatorial exercise. It's as much an intellectual exercise as, and I mean, what I was saying is if you run a court where that kind of alpha male aggression looks foreign, it might curb it.
I mean, I took from this piece just something that I really admire about having got to know you over some years. You said that this way of approaching the court as a workplace. The first is simply to be aware constantly of the power imbalance between bench and bar. A raised eyebrow or a scowl or a careless barb can have serious consequences in a given context. This is not to be oversensitive. It is to recognise reality.
Yeah.
Now, that
judges are pretty scary.
Yeah,
and I thought Nigel Bowen was pretty scary until he realised he was one of the most gentle people I've ever met, although he was as tough as nails. And someone told me, I mean, there was a particular, I won't go into the personalities, but I remember a case I was in, and it was about security for costs and class actions. And I thought what the barrister was putting was rubbish. And I was having a bad year in 2013 for various personal reasons. And I was later told by someone else who was at the bar table, who said to me, I won't use precisely the words that were used. He said, "You are, a complete bastard on that day." I said, "No, I wasn't." He said, "Sure." You sure? That was quite an experienced silk who came out of that. And I accepted that. And because the person that was telling me was a pretty perceptive and tough individual. But and I thought, And John Ireland, who, barrister, who said to me, we were having a drink in common room, time when I'd had a bar, not long after I had started on the bench. And he said, you've just got to kind of calm down, he said, you're a bit bad-tempered sometimes. Because you do, you kind of, you get short, I've got a certain shortness of temper, which, Sandy will tell you about. And I said, no. He said, yes, you are. I said, no. He said, yes, you are. You're scaring the young ones. And I said, really? He said, yeah, scaring the young ones.
Yeah.
Ooh. And because you don't see yourself because you're inside, not outside. You don't see yourself. And you have to be aware of that. And if you don't have that, and that came, you've got to have that, and you've got to realise how you can, because you're in your 60s, you might be in your 50s, you think you're young in your 50s, but you're still old compared to the 28-year-old barrister with a client. And
trying to get their career.
And that's why the people that I remember, I gave some remarks. It's one of the best things I've ever written. I was asked to speak at David Hodgson's funeral service by his wife, and I said, look, Raewyn, there's people who knew David more than me. And she said, David and I spoke about this. He wanted you to do it because you were his president in the Court of Appeal. And kind of that was, oh.
Wow.
And his gentleness when, and I spoke about him, you know, peering him, and he just began to talk to himself. He said, well, there'd be this idea, you know, be this idea. But hang on, there'd be this idea. You know, the problem's being solved by this huge brain on the bench. And you're there, it's two 28-year-olds that kind of fighting over some will or something, like TFM. And when he wrote the judgment, all these wonderful ideas were all ascribed to each counsel. This, you know, and Mr. So-and-so submitted, you know, and he was loved because he was so, he occasionally lost his temper, but he would always apologise to you in the place that was appropriate, which was in court.
In the court.
And Brian Cohen was like that, Dennis Needham, and you know, they could be short with you, but they were kind people, and a little bit of kindness is not.
Does that hark back to one of the pressures that barristers feel when we talked about the performance pressure?
Yeah, and as a judge, is a different. You get it. You're busy, and the real place where you can be rude to people, and not mean to be, but you know, is if you're running a list and trying to get through the work, and someone's being a dill, and it's not. You know, they're doing their best.
Yeah,
you know,
and that because I think that performance pressure of trying to not only ensure that your clients are getting the best job, but you're also enhancing your reputation at every stage, or you're being approved is also like a big feature of, I think, the barristers' performance.
But I remember there was a very nice man and very good silk from Melbourne who was arguing. It was a defamation case in the federal court. It was before Justice Rearies and Bazanko and myself, and I forget, and he was putting, the silk was putting this proposition that was just wrong. And I said, some difficulty with it, you know. And then he said, let me put it again. And he put it very elegantly. And I said, and I looked at him and I said something to the effect, apart from the elegance with which it was put, there's not much to commend it. And he said, seems to be getting worse. I said, it is. But that was done, and he was, but you've got to be very careful. In another case, I remember saying, I saved a person because this person was about to be monstered. Yeah. It was a full court.
By the rest of the bench.
By the rest of the bench.
I'll just jump in here. Yeah.
And I just jumped in and I said, so-and-so, you can't just stick a tail on it and call it a weasel.
Yeah, right.
Which was a kind of variation of a blackadder. And unfortunately that person, I think, held it against me because, anyway, but it saved that person from a kind of terrible monstering from one of my colleagues.
And there's a way of doing it if you want to indicate what you really think and doing it more kindly, maybe with humour or what have you, and you don't have to be cruel.
Unlike the time I asked a judge who said to me, that's not your best point, I said, sorry, is it my best point or not my? I didn't hear it. Is that my best point? Not my best. Ah, right, not my best point.
Yeah. Did you say, well, that's my only point?
Well, I had.
So that'll have to do.
I went to that point thinking.
Well, there was a commercial court judge who said, "I'm busy this afternoon, but I'm going to hear your case," and he said, you know, it was quite a narrow case, and he said, "I want you to give me your very, very best point."
You didn't turn up.
And I did, and he said, well, it's wrong for these three reasons. He said, can we stop now? And I said, yep.
That'll do.
That'll do.
Well, look, that might be an appropriate time, as what judges often say, is it an appropriate time? James, it's been fantastic. Really,
one of our favourite things to do.
Like, it really is such a great honour, and I know that sort of thing gets said a lot, but it genuinely is for you to come here and talk to us about being a judge, being a barrister, McGilchrist, everything we've covered. It's been fascinating. So thank you so much.
Pleasure.
No, and from my part, thank you.
But the one thing I did miss, you'd asked me, there was one thing I did miss.
Yeah.
going to the bench in the bar. No more cross-examination of experts. I enjoyed that.
Yeah.
I loved it.
That's
When the experts are there looking at you, go, what can you ask me?
Yeah.
And then 3 or 4 days later they're going, I didn't think it'd be like this.
On technique, I remember something interesting you said the other day when we were talking. You said that your two ways, you either shift them a little bit to where you want them to be so you can make your case, or if they've been intellectually dishonest, you
take them apart.
You destroy them.
Yeah, it's
Try.
Or just make them realise that, because the reality is what they don't, which I used to always tell my experts, you know the whole field better than this person ever will because you've lived your life in it. The case is not about the whole field. It's about this windy little path through the Black Forest. It goes around in funny little directions, and all he has to know, or she has to know, is that windy little path and sufficient area on each side of it, so if you knock him off or her off the path, he can get back on. That's all that he or she has to know. And when you start, trust me, he or she will know more than you about that path. And they'd go, no. I said, trust me. Or just assume that he or she does, because that's all the case is about. It's not about your field. It's about the windy road through the Black Forest. And you want to be very careful. And that's why it was such fun.
Yeah.
Because no expert ever knew it was coming.
That's another podcast probably in itself.
well, I mean, we could go for
technique. James, fantastic.
Thank you.
Pleasure.
Thanks for being here.
That's all we've got time for today. I wish we could go on, and we could for a long time. Thank you, everybody, for listening or watching, and I hope you've enjoyed it as much as we have.
Thanks, Nick.
Next time, in their final episode of this season, the Elephants talk with Justice Peter Hamill of the New South Wales Supreme Court about the important issues of mental health and judicial bullying. They also go light when they cover the judge's love of the Boston Red Sox and his infamous judgment head notes. This one's a beauty, so please tune in again.